Call the July 27th, 2016 Town Board Work Session to order. We'll let the record show that all the board members are present, along with members of staff, as well as our legal team is here. If you happen to have a cell phone in your pocket, in your purse, or whatever, if it is put on silent, that would be very much appreciated in respect for the discussion by the board this evening. Thank you very much. Before us, we have the minutes of July 13th, 2016, and I would entertain a motion of approval for those minutes.
So moved.
I'll second.
So moved and seconded. Is there any discussion on those minutes? Seeing none, those minutes are approved as written. Thank you, Lisa. I appreciate it. Monthly reports. All of the monthly reports are in, except for two areas, one Public Works and Personnel, and I would expect they would both be in by the end of the week. So thank you to the department heads for that. This evening we have no public hearings. This evening we have no guests. We'll move right into our action items, and we'll start with our first item under Lawn Finance. It's the Oak and Apple Cidery. This matter was a tabled matter before this board for a number of meetings to give the town legal team an opportunity to follow up and review comments and information materials that have been submitted. And with that, I would turn the discussion over to Mr. Horwitz and Mr. Weishar for their comments.
Thank you, Mr. Supervisor. This matter was tabled 2 weeks ago on receipt of requests for clarifications to certain points that were raised by Mr. Gallagher. And the purpose of my discussion tonight is to address each and every one of those points. The first point that he raised is all the property contained within the 2002 Wilmes Conservation Easement is defined as farm area. There is no farmstead. That is a correct statement. Point 2, the conservation easement defines distinctly different activities allowed within a farm area and a farmstead. That also is a correct statement. Point 3, Oak and Apple has acknowledged that their proposed development can only be constructed on a farmstead. See the June 5th, 2016 letter to the town board. This is a correct statement also. Point 4, the only right to create a farmstead is for a winery. See Section 3, Farm Operations, B, Farmstead. The response to that is that this is not a correct statement. All types of farm uses are allowed to have agricultural support buildings in a farmstead area. A, the easement provides that the property shall be used solely and exclusively for the purposes defined and described in Section 301(2) of the New York Agricultural and Markets Law. B, the Agricultural and Markets Law, Section 2, allows a cider mill to be considered and protected as a farm operation. C, the New York Agriculture and Markets Department guidelines state that a cider mill operation is a protected farm operation. D, easement Article 3B, entitled Farmstead, provides in Section 1, page 10, that the owner has the right to construct new buildings, including but not limited to barns and farm market buildings, including a winery and suitable tenant housing. The easement language does not limit the farmstead and farm operation buildings to only a winery. Any farm operation that would be done on the Wilmes easement is entitled to request a farmstead area to build support buildings for the farm operation. Point 5, the right to farm does not include a right to create a farmstead. They are allowed farm activities only, embraced in the term right to farm. The response to that statement is that the owner's right to create a farmstead area, the right to request one, is set forth expressly in the conservation easement. The Agriculture and Markets Law, Section 308, regarding the right to farm, does not embrace the subject of farmsteads. That's a subject that is expressly covered in the conservation easement. Point 6, all remaining development rights are transferred to the grantee, the town, and are terminated. This includes cidery, brewery, rendering facility, housing, hotel, or restaurant. See Section 4, rights of the grantee, 5, development rights. The response to that is, as has been previously stated, the easement provides that the property may be used for farm operations and agricultural support buildings and improvements. All the remaining development rights for uses that are not permitted by the easement are terminated and extinguished. A cidery use has been determined to be a permitted use. So, in my conclusion, after reviewing all of the input that has been well done and has been articulated by people both in favor of the project and against the project, after reviewing all that, the language of the easement and the town's contractual obligations under the easement, I must say that this town board has no legal right to not have the planning board hear the site plan application for this project. The town is absolutely required by law to have this project heard by the planning board. There is no discretion, and it's a legal obligation embraced not only by these documents but by our zoning code that says that an application for a site plan that contains all the proper materials must be heard by the planning board. So for those reasons, it is my strong suggestion that this board authorize the supervisor to send a memo to the planning board to continue deliberating on the approval or not approval of this project. Any questions?
Questions, comments, board?
Regarding the easement and protection of open space, I think there's been some concerns raised that this was perhaps part of a greater open space plan, or is the primary purpose to prohibit or prevent or impede anything but farming on this property?
Great question. And again, I go back to some of the discussions and some of the language in the conservation easement that we were looking at and addressing when this board came to the conclusion that the cider use is a permitted use. In the purposes section of the conservation easement, it is stated that protection and preservation of agricultural resource is identified as the primary purpose. The preservation of open space is also a purpose to be preserved. But also in the document, it expressly states that view sheds enjoyed by the public at the time of the town acquisition are to be preserved provided they are consistent with the active farm use of the property. And part of this proposal, the planning board is going to make a determination as to where these structures are going to be on the property, the impact on the view shed. But for to support agriculture and to support the topography of this land, the planning board's going to have to make a decision. And the prime preservation goal of this easement is to have farming and farm operations be successful and operate. And taking into consideration the views, both from the roadways to the property and from the property out to other areas. I mean, this is not a property that had a scenic overlook that the public enjoyed at the time of acquisition. So I hope I'm being clear that agriculture is the prime goal to be protected under this contract, and view sheds are also to be preserved, but are sort of subordinate if there's a bit of a conflict.
Or ancillary, and the planning board would have to look at what the view shed was in 2002
Yes.
in terms of preservation.
And what it is today.
And whether any view sheds would be, you know, just plain devil's advocate, whether any view sheds would be increased by public access to the property. Not that that's ancillary, but that would be.
It's a very good point, because this has always been private property. Nobody had the right, and there were not trails, there were not overlooks. There was no place on this property for people to come on to the top of a hill and look at the beautiful countryside. That wasn't the case. Now, with a business and an operation to which the public is invited and maybe can use, there would be, in my judgment, an enhanced opportunity for the public to enjoy the view from the property. The view from the roads to this property, as it gets developed, is going to be impacted. And I think the planning board is going to take all the considerations, or should take all of those considerations when approving or denying a site plan.
And take me back to 2002, not to date how long you've been involved with counseling the town board, but
Goes
I
back
was
a lot longer.
here in 2002. Certainly there's an agreement, you know, just obviously in just my legal experience, the agreement is meeting of the minds. Agreement involves two entities coming together with their own intentions, their own goals of the agreement. And is it your recollection or your opinion that when the Wilmuses entered into this agreement, that the meeting of the minds was fueled by the desire to continue agricultural production in East Penfield versus other types of residential development, commercial development, and the like, versus open space?
And versus development for homes, let's say, for the sake of example, if it was zone residential 2-acre zoning, the desire was to preserve agriculture. So Mr. Wilmus, in addition to the right to create a farmstead for any kind of farm that could be on that property or farm operation, he was concerned all his life with the grapes. And he had this dream, potentially, of establishing a winery. So the provisions regarding the winery were negotiated between Mr. Wilmus and the town because he had the strong desire in his particular agricultural use to make a winery. And the town negotiated all kinds of protections in the conservation easement to limit this, let's say, the size of the winery, so as not to have a Wegmans operation, purely commercial operation. It was designed, this easement, to and specifically reserved to him and any subsequent owner the right to have a winery. But other types of farm operations were not excluded. The language of the easement expressly provides that you can have barns and silos and tenant housing if you had the need to support a certain kind of farming.
Those other structures are not pertinent to a winery operation.
Absolutely. So, so that's...
Can I add, One of the things, so you were talking a little bit about kind of in the context of open space and where the agricultural aspect fits into this and the broader open space plan. And in the beginning, where in the statement of purpose, it talks about in the context of the open space plan, and it says those plans identified a resource protection as an important element and further established the goal of preserving agriculture and open space within the town. And in that same section, it also talks about these parcels of land are critical of the community's planning efforts to preserve agriculture as a resource and as an industry within the community. The historic agricultural use has been important to the community's economy and provides a scenic beauty, which is clearly identifying the overall character of the community. So, not strictly, I think, because you were
Saying that he had
tied to the
agreed only a
agriculture.
winery, it must be a winery, and if it's not a winery, then this contract's void, would be contrary to what that preamble says.
That's right.
Oh, and contrary to the intent, because the town of Penfield wanted to preserve the right to farm in any form whatsoever on that property.
Yeah,
And he didn't know if he'd ever do a winery, so a farmstead was never established at the start because he wasn't sure he ever was going to be able to do it.
So would it be your opinion that the agreement was struck whereby Mr. Wilmus had a desire to have a winery production, but that if he had said to the town, it must only be a winery forever and ever and ever, the town would not have entered into that agreement? Contrary, if the town had said to Mr. Wilmus, and based upon the intent as set forth in the preamble, that if the town had said to Mr. Wilmus, we want to not have winery ever listed in this agreement, we would not have had agreement.
Absolutely. Absolutely.
And the winery language that appears in the farmstead section, Mr. Horowitz talked about, the structures that are permitted, and it talks about barns, greenhouses, dryers, silos, fuel tanks, general support buildings, farm stands, farm market buildings, and then it says, including a winery. So that's different than if it said, if it was only going to permit a winery, it would say a winery only is permitted. It doesn't. This is in the context of, this actually sentence begins in describing the buildings by saying, including but not limited to barns, etc. So it's clearly not restrictive in that sense. There are other restrictions that are specifically listed later, however, that, no banquet, party, facilities, or outside storage shall be permitted. So when the parties wanted to restrict something, they put it in there, and they didn't do that for, limiting it to a winery, for example.
You can see my questions are, you can probably guess my questions are driven legally by, what a court would look at, what the Supreme Court would look at if it had to analyze this situation. They're going to look at more the four corners of the document, the intent of the parties behind that easement, correct?
Right. Correct.
As to whether the use is permitted within the confines of that conservation easement, more so than they would look at the conduct of the parties today, other than the proposal, on its face.
Right, the contract language speaks for itself. The intent of the contract is articulated by Doug Fox and myself, who drew this contract and negotiated the contract. Would say that all farm operations are entitled to be performed on that property. Farm support buildings are what was contemplated and what the town bargained for and what Mr. Wilmus bargained for. He wanted to protect himself and make sure that any town board members or people in the town realized that he wanted a specific reservation and wanted to emphasize he wanted the right to do a winery within a farmstead if he chose to do it. So that's how that winery provision got put into the agreement. It's not in any other conservation easement the town has.
And it was a bargain for consideration.
That language, you won't see it in any other conservation easement.
So that raises, you kind of just answered my next question, is the winery aspect of this easement that was first raised by the landowner at that time?
Absolutely.
Right, okay. And that winery, the winery language is only specific to that particular parcel?
Correct.
Okay.
To his property, yes. You would not find it in any other
Yeah, okay.
conservation easement.
All right.
So you concluded earlier, Dick, by talking about sort of the next step. What did you, can you repeat that? That was to draft a memo of some sort?
Yeah, my sense is now the town should be at the point of authorizing the supervisor to send a memo to the planning board to say resume the deliberations on this application. I think as I said before, I think the town's hands are tied. I think the contract language expressly states what we've just talked about, and the applicant has a perfectly appropriate application for a site plan application to be considered by the planning board, and I think that should be the next step.
Right, it's not that there's any recommendation obviously for approval, because this falls in their
Correct.
jurisdiction to review and get public input and follow their procedure. At this point, our task is to, as I think as the supervisor said, we've spent weeks researching and mulling and deliberating over this, but our task is a narrow one, it seems, given especially that the planning board procedure right now, they're only at the informational hearing stage, is that correct?
They actually had a sketch plan concept review, and then the applicant submitted a formal application for site plan review. So that has not yet been heard. The first step would be a public hearing, and then the question would be considered the standards under our code for site plan review. What the planning board is charged with looking at would be those aspects of the development. And the reason why I came to the town board was because there was a question about whether or not the use as proposed was consistent with the terms of the easement. This board is the board who approved the easement, so that's why I came here and having reviewed that. And, our recommendation is that it is consistent as approved, and then the planning board should then continue.
As applied for, it's consistent.
That's right.
Let me ask you some more specific questions that certainly have, I think, been concerns of residents that have raised concerns to me as to whether at the outset, now again, it has not gone before the planning board, but whether at the outset there was some representations made by the applicant regarding the nature of this operation. So can you answer for us, does the conservation easement permit a bar to be a proper use?
No.
A saloon? A party house?
None of that. In fact, there's a restriction on, you mentioned party house.
Gathering place?
Yeah, there's restrictions on that. Those, no banquet, party facility, or outside storage. Those are strictly
Large
prohibited.
retail operation?
Those are, those commercial rights are extinguished.
So that is something that would be, the planning board would be advised on, as far as if in fact the applicant is desiring to embark upon, seek into, expand upon their use, that those are not permitted uses.
There are certain ancillary uses that would be consistent with the Ag and Markets Law and the right to farm. And so if they're going to expand, I think, beyond what's proposed, then, there probably would need to be a review, perhaps it would have to come back here.
Yes.
But we don't know what we,
You're right.
yeah, it's hard to say now in the abstract.
Or if what has been proposed within, as it's vetted out, facts come out that dictate that, maybe they're trying to do something even though it's not stated, or, by the hours, or by the production of cider, what's going to be done with that. Is that part of, then, does that come back to the town board if there's additional uses and there's some dispute over whether this is in fact a place where someone can go and drink cider all afternoon?
I think that that question is a good question. I think it's premature because we don't know exactly the details that are ultimately going to be presented by the applicant and in terms of the operation of the cidery. And if there are issues that should appropriately be determined by the planning board and or the town board, we are going to have to address at the time when they become obvious. So it is, as
It's good to have on the radar, but it's not part of...
Right, it's not a black and white area until we hear the actual kind of use that they propose.
But there is language in the agreement, as you said, Pete, that talks about, no meeting area, no banquet facility, so it's not going to be a party house or that
Correct.
type of activity, right?
Correct.
Because sometimes the way the ag and markets law has been interpreted is broad, and so that's one of the things that this easement specifically said. Granted you the opportunity to have whatever is the right to farm would permit, but then it took a couple things back, like things that would be inconsistent with this particular parcel, such as the banquet facility.
Right.
So
Going
those
back
are
to the
specific.
intent of the agreement was to preserve agricultural uses, agricultural production, not agricultural production and anything else that you can do related to agriculture.
Correct.
I mean, there may be uses that might have been suggested or are appropriate by the Agriculture and Markets Department, but are prevented by the language of the
This could be more
conservation
restricted
easement.
than
Or
ag
tighter.
markets.
or
I think
tighter.
that it is.
And it is.
In regards to banquet facilities, because there's even, I think there's some case law that talks about, there, and in that case, I think it was in the context of a winery, and they had weddings and stuff in the facility, and that was viewed as kind of ancillary to kind of foster agritourism, for example. But that's why, I'm assuming, when this was drafted, why there was some carve-outs and take-backs, and say you can have the agricultural uses and the right to farm, but no banquet, party facilities, etc. Specifically enumerated.
So just because it's in the ag and markets either statutorily or via guidelines does not mean that it's permissible
It
here.
may violate the easement.
Yeah, you'd have to look at what's proposed and what the easement
But
provides.
it's not a blanket, just because it's in ag and markets, you can do it
That's right.
under this agreement.
Correct.
But with what we've looked at, though, as far as what's been proposed and the four corners of what's now before the board, that would be consistent with the easement.
Are there also guidelines regarding on-site consumption? I mean, I would assume that either Ag and Markets or the State Liquor Authority has some form of guidelines of the differentiation between an Ag and Market operation as opposed to a bar.
I think that the state, I don't know, I think though typically those issues are not issues that can be regulated locally. Those are governed by the terms of the license given by the
Right,
state
and I
liquor
understand that,
authority.
so I assume then,
Correct.
if our hands are tied on this and it goes back to the planning board, one of the concerns that I have, as well as some of the residents have, is what this operation is going to actually look like at the end. So I would hope that the planning board is going to be doing a deep dive into what actually constitutes a cidery operation under the Ag and Market Law or easement and possibly the State Liquor Authority as opposed to what it doesn't. So-
Yes, they're going to be conferred a certain license by,
Okay.
under the alcohol statutes, and that will be certainly examined by the planning board.
And I know, so the planning board, what the planning board typically does, and I can't speak for the planning board, but they are concerned about uses coming into town or proposed operations, and, is it gonna, like, if a business were to leave a new structure, and is this gonna be consistent with the neighborhood, and, so they do look at things like that, and that's why, they're gonna wanna make sure that this is gonna look like a farming operation. so that if something were to happen, it's still going to look like a farm, and so that so you're not going to set it up as so the next person comes in and says, well, I need a variance, I need a use variance or something, you know?
Yeah, I need a
But so it's going to look, I think that's what the planning board's going to try to do.
full-blown restaurant.
And Dick, I just want to make sure, I know, I think you've said it once or twice now, but as legal counsel to the town board, you made a statement earlier, and I wrote it down because it was a pretty strong statement, but something along the lines like the town board, we as a town board have no legal right to prevent this from moving forward to the planning board?
That's
Is that
correct.
an accurate statement?
Absolutely, yeah. I think board is required, the town is required by law that this matter go to the planning board. Yes.
You know, what kind of strikes me, and I'm never at a loss for words, what kind of strikes me is why, is I think you can see we've wrestled with this on behalf of the residents, but I think I've wrestled with this just internally because in Penfield, this is unusual for us to be considering this and having this type of conversation about a potential business. It's been my experience, not only growing up here, but now on the town board, that when businesses seek to come into our town, they want to be a part of the community and they want to embrace their neighbors. And we've had even very recently examples of businesses who've gone to great strides to compromise, to listen to neighbors and their concerns, to make concessions that may not be in the best interest of their business, but they're certainly the best interest of community. It saddens me that, especially in East Penfield, because it's kind of ironic that I would believe that this property was purchased because it is a beautiful piece of property in a beautiful part of our town. But yet, the people and the generations before them who surround this parcel, who are part of East Penfield, who've made East Penfield what it is and what this easement is trying to preserve, are not being hurt by the applicant, from what I can see, by anything in the project being in any way at this point. Now, I am hopeful that the planning board is going to have a much different experience when it comes to what ultimately may be approved here. But I feel for the residents in this area who have created this neighborhood that I assume is one of the reasons why the property was purchased. And that saddens me, that location, 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 as they always say in real estate. Well, who made that location for you? And I think that that's one of the reasons why I have wrestled with the issues before us and the questions before us, and some of the documents we've received. I've wrestled with digesting them, because I certainly think that this is an area that back in 2002 and well before then and now, we're seeking to preserve the agricultural fabric of our community. And I would like to see that, like businesses in other areas of town, that this venture embrace that as well.
Other comments, board? Any members of staff, any additional comments? Mr. Horowitz, Mr. Weischer, any additional comments?
I don't think so.
So based on the conversation, what I'm hearing from our attorneys is that upon review and analysis, not only of the easement, but of all the materials that have been submitted to us for review by neighbors and others in the community, that you're indicating to this board that this proposal is consistent with the easement, and therefore this board must in fact refer that to the planning board. And the recommendation from our town attorneys is that I draft a memo on behalf of the board for ultimate review by the board and the town attorneys to move this forward to the planning board for their hearing and review.
Yeah, and Tony, I kind of concur with what Paula had to say. I certainly hope that the planning board, understands and hears this board's concerns. And I hope that the applicant hears, this board's concerns, and that, something positive can come out of this application as it goes to the planning board.
And I will note my great constraint with moving this forward to the planning board. But I certainly have mulled over, researched, and digested what our council has researched as well. I also would assume that, as other agriculture operations have in the past in our town, the farmers embrace the operation. I think it'll be very telling to see how many of our farmers come out in support of a fellow farmer, purported to be a fellow farmer, because that's been the history in our town, is that our farmers support each other in their operations. And I would hope that then would show, if that is the case, that there is certainly this preservation of agriculture, and the neighborhood and the character of the neighborhood is being carefully considered. Because that will ultimately make for a successful venture. Our experience with businesses in this town is those who alienate their neighbors do not succeed.
Okay, I will prepare a memo for review by the board, working with the town attorneys on this for the board's review, and once that is completed and signed off, that will be part of the record and part of the website under the Oak and Apple section of the website. And then the next step will be for the applicant then to move to a formal planning board hearing. Okay, all right.
Thank you very much. You guys spent a lot of time on this, I know, and answered a lot of questions. Thank you.
All right, we will next move on to our second action item under Law and Finance. That's Abbington Place Subdivision, Section 5, 1229 Fairport, 9 Mile Point Road. And I would recognize Mr. Costello for an update on this application that we heard last Wednesday.
Thank you, Mr. Supervisor. We did hear the application last week. The applicant has been working with our town engineering staff to ensure that the questions and comments that came up at our PRC comments have been addressed. We feel that they have been. There will probably be more comments coming to you in the next phase, which would tie in the last phase. That would clean up the entire subdivision. But with respect to Section 5, I think we're in pretty good shape.
All right, questions, comments for Mr. Costello? Any additional items? And consistent with what we talked about at the public hearing, all of the items with PRC, including that stub road that I know was very important, and an extension of that is part of that conditions of approval for this as well.
That's correct.
Okay, very good. Other questions, board? Staff, Costello, any additional comments? Okay, we'll prepare a resolution for the board at our next meeting of August 3rd for that matter.
Very good.
Thank you. This will take us down to our sign ordinance item under informational items, and just wanted to report back to the board through our conversation as it relates to signage in general. Mr. Costello, Mr. Horwitz, and myself did speak. A couple of things that we thought is very key from a review standpoint is that we've had the town board as well as the zoning board of appeals have had a couple of applications here over the last several years as it relates to multiple signs. Each board or each respective board has taken a look at that closely, and in many cases has approved, in a few cases has not approved those. One of the things that has been pretty consistent throughout the business community in general is that that aspect is something that should be looked at and considered. So we've heard that very loud and clear. One of the recommendations that we're making to the town board is that staff, myself, and Mr. Horowitz prepare some revisions and some refinements to the board to take a look at that multiple sign for businesses and to make sure that our businesses are being properly and adequately represented. Certainly, a number of signs and square footage signs, there is an opportunity there, and I think in many cases, I think why our board and the zoning board has granted is that it has been within the square footage, and rather than having one big sign that may be out of place or out of character, maybe multiple signs might be more appropriate. So we'll look at that. One of the other things that I think we heard, in some discussions is the event signage and what's the right amount of signage for that, and actually the number of times that it may be permitted. So our recommendation back to the board is that we take, even though we had made some changes a number of years ago, that we take a little bit deeper dive into a couple of areas within our business districts and to make sure that we've done our due diligence and appropriately provide signage that helps our businesses continue to grow and flourish within the town, and done very tastefully. So our recommendation back is that if you give us a couple of months, we'd like to come back and do a revamping of the sign ordinance and make that consistent with some of the things that we in fact have heard here over the last 6 or more months.
Yes, thank you. Sounds good, yeah.
Okay, great. So we'll show this as a held item, Lisa, and Dick and I and Kaz have already started having conversations. We'll bring Andy Cervegas into that as well and complete that review and study. Okay, with that, there are no other items on the agenda for this evening, so I would look to adjourn the July 27th, 2016 Town Board Work Session at 7:43 p.m. Thank you to everyone that participated. Thank you, board and staff, for your ongoing support.